Okay, we're recording. So I want to introduce my friend, Coach Neighbors, to, of course, what's this called? What do we call this show? Foreclosure Defense 101?
Yep.
And more, right?
And more.
And more. So, Coach Neighbors, what do you have in store for us today?
Hey, everybody. Welcome. Gene, I'm really proud that you guys are allowing me to come and talk to everybody. I have an assistant here who, come on. I have an assistant here who wants to say hi also.
Oh, yeah, the buddy.
This is my assistant, Portia. Can you say hi?
Hi, Portia.
She's like looking around to see where you're at. Okay, there she sees herself in the camera now. She's like, she's a ham. She's been working on this. Okay, she's telling me I need to leave now. she says, I got this. Here, I got a treat for her. Here, there you go. Oops, there you go.
And I will add to this real quick that I don't think there's a lot of radio stations that will put this show on because they're not willing to accept or deal with attorneys, courts, and companies because they're afraid. And I'll be honest with you, after what I went through the last 10 years, I'm not afraid anymore. So.
And I respect that, Gene. I was real surprised when you contacted me to, wondering why, because I get a lot of pushback for what I do. I'm a paralegal. Actually, that's the word that I use so people can kind of understand where I am, because I'm past that, because paralegals do stuff for attorneys. What I do is stuff to help you kick attorneys' butts. And I have researched their loopholes and procedures, and that's what I use. I had a guy tell me one day, hey, this should be about case law and all of that stuff. I was like, you know what? Let's keep it simple. When you get done with the facts, okay, there's not going to be any need to do the case law thing because the facts are going to
That's right.
And people don't know the facts. So today we're going to talk about the tricks and the deception that people have to go through to get their lawsuit filed, to keep their lawsuit on the record. One of the things that I tell people is part of what you're going to have to learn how to do is to stay in court. People are like, oh, I want to win, blah, blah, blah. No, dude, no, that's way too much, okay? To win, to me, is having the judge give you everything. I have not seen that happen. There's some case laws that said that happened, but I have not seen that happen. So my goal is to teach people how to force the parties to visualize the shared liability, and make them quit or stall or give up. I have a lot of cases where they're stalling. And our number one goal in foreclosure defense is to keep you in the house. That's it. I played football for the University of Kansas back in the 80s, and I boxed for 4 or 5 years. I went to Delman Conde, so those are things that not real smart people do. So I have to keep things simple. And when you keep them simple, it alleviates the arguing. And people don't realize, everyone wants to go to court and do all of those rules and do all that stuff. But at the end of the day, all you're doing is setting yourself up for the arguing, because you're discussing what they want to talk about. And once the argument starts, well, what happens? The judge gets to help them.
Right.
It's pretty much plain. It's how their program is structured. So structuring the program. So we're going to talk a little bit starting out about the tricks the court uses to illegally dismiss your claims. And I think this is going to be very interesting to a lot of people. So where do we start? So the one place I want to start first is the magistrate judge does not have jurisdiction in your case without consent from all parties. And I had this conversation with my wife one time. She's a legal person too. And she was like, oh, no, the master judge, you know. And I'm like, no, sweetie, no, that's no. Because when I was working, I was like, okay. So she was playing with everything. So I just typed in magistrate judge consent form, Texas, and hit the button. And it pulls up the form from the Texas court, the magistrate judge consent form. And it says clearly right on there that the magistrate judge must have consent from all parties according to this statute, blah, 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 blah. And if the magistrate judge does not have consent, it's a problem. And the magistrate judge never has consent because they never send you that form. And no one, if they do send it to you, most people throw it in the trash can. So you're consenting through acquiescence. Now, the thing about that is the magistrate judge is a lower judge.
Right.
So there's no way I wouldn't want a lower judge. I don't want the other judge making a rule in the case because that judge is full of crap too. But anyway, let's just stay focused. So the magistrate judge is a lower judge. So what happens is the magistrate judge looks, the district judge looks at your claim. And if it's a hot potato, and if you got it from me, it's going to be real hot. They don't want to get their name involved in it if it's addressing the issues with the attorneys, because it ain't the lender that's suing you in foreclosure court. It's the attorneys acting as third-party debt collectors. And if you put that on the table, they ain't going to want to touch it. So that's what you throw on the table. So the district judge is going to take the case and hot potato it down to the magistrate judge. And the magistrate judge will take a look at the case. And in most cases, they move to dismiss for failure to state a claim under Rule 12B. Yeah, I've seen that a long time ago. Don't get me wrong. and then the magistrate judge will make a report and send the report back up to the district judge. And the district judge will dismiss your claim based on a freaking report from the magistrate judge and not a judicial decision. They will not issue conclusions of law, facts of finding as conclusions of law with his order. And most people don't know that you have to have those things. And if you don't have those things, then it's not considered. How are you gonna oppose it if they don't put from what authority they're throwing you out the door with?
There's a question there, and I think, well, a comment too. First of all, we know that judges respect other judges' decisions. That's first and foremost, whether they agree or they don't agree. But like you always say, and you did say this too, in federal court, the judge doesn't have to respect the decision in the lower court. And I like that you have that little bit off level this.
Well, actually, Gene, it's stronger than that. The federal court, and this is one of the key things and the strategies that we use. So I'm glad you bring this up. And my presentation is set up to where if anybody has questions, you can throw them on the table. Then I have some little notes over here that keep me kind of on track, so that we keep everything in order, so so people can better understand it. So that's perfect. So the problem with that is, well, we'll get back to that.
Okay.
We'll get back to that. So the magistrate judge, when the magistrate judge dismisses your claim and sends it back to the original judge, and that judge throws you out the door based on the report, most people don't realize that you need to file your motion for reconsideration. And you need to attack the judge because that person is blocking you from getting in court and illegally. And if you don't make an issue out of it, they will just keep mowing you over and doing the same thing. You know, there is a form that you can fill out to object to the magistrate judge's consent at the beginning of the process. But for me, I would rather wait and handle it after the fact, because you got to remember, your job is not to hurry through court so you can go and talk to the judge and have the judge rule for you. That's not the way that you're going to get anything done. So your job is to stay in court and keep getting on the record what you need for your appeal and for your lawsuit. Now, I have no faith in the appeal, but you can use that process to buy you time if you need time to get yourself in a position. Now, the other thing that people need to understand is that there's two United States of America. There's two United States. There's United States of America, which are all of the states together, and then there's the United States, the federal corporation. And the United States Federal Corporation has kind of tricked everybody into believing that you're citizens of the federal government, of the federal corporation. So they make you pay income tax, they make you do all this stuff because you're citizens. Now, this is my opinion from my research. Yep. So I'm not telling you guys to believe me, do your own research and figure it out. So what they've done is, in the beginning, the people in Washington, D.C. were the citizens of the federal government or whatever. Right. And they since expanded that because they're tricked everybody into believing that you are. And most people have no idea. But see, here's the thing. Nobody can be a citizen of the federal government because the federal government is a fake entity. The federal government is a corporation, a fake entity. Nobody can be born there. It's keeping it simple that avoids you to get caught up in their bullcrap. And so if you weren't born there, you're not a citizen, you're not obligated. And this is why that passport process is so important. We'll talk about that at a different time. Mm-hmm. When you reclaim your state citizenship, then the court does not have statutory jurisdiction of you without an injured party. And that's why that process is, I actually have affidavit of state citizenship on my website. I think I have it priced for $50, which is designed to do the same thing as the passport process, except the passport process, you get the card from the state showing that they can't touch you without injured party. It's like getting on the do not detain list. It's like diplomatic immunity, basically. When the police pull you over, you give them your state citizenship passport, and they run it, and it comes back that you're on the do not detain list, and they leave you the hell alone and get out of your face. And you use that also, but we'll talk about that later. So the administrative courts, that is what we are in, an administrative court. An administrative court with no judicial authority. That is what we're in. That court is not connected to the Constitution. And it does not have to respect you. You have no rights in that court. And anybody that's been in court will know exactly what I'm talking about. You have no rights in that court. So how the hell can they do that? Well, because you don't know how to address the problem. And that's what we're learning how to do in our processes. My YouTube channel, I think I have 85 videos. All of those videos were put together from experiences from people all over the United States in my private Facebook page. Mm-hmm. And so whenever attorney responds or whatever they do, people contact me in the group and hey, this is what's going on, or this is what they tried, and it allows me to change things, address things, add things, so that other people on the other side of the country don't have to deal with the same problem at some point in time. And eventually you get things wrapped up real tight. And that's kind of what we're doing. But people need to remember that you're in an administrative court with no judicial authority. And when you go into court, especially if you're, well, anytime, especially if you're in foreclosure, the only thing you want to talk about is the jurisdiction issue. They do not have jurisdiction. And since you guys are watching on the radio show, I'm going to just share with you why. And the statutes that they use to foreclose on you do not contain the necessary elements to be considered a valid law. They do not have an enacting clause. They do not have a title. They do not have a body. All of those three things are necessary according to your constitution of your state, and all laws must be enacted. Well, these statutes and codes are not enacted. The revised statutes and codes are not enacted.
That's right.
They are not. And this is part of what I do. I pick at their stuff from the beginning, not in the middle over here or in the end where they said you owe them money. That is huge because that code and statute, the revised statute that they're using to provide jurisdiction to the court, they're using it as if it is a law. And it cannot be a law if it don't have the necessary elements. So the foreclosure against your property is unconstitutional.
Does anybody get that? Repeat that again so they can hear it again.
The foreclosure against your property is unconstitutional because the law that they're using is not a valid law. It is a revised statute. And you can look up what a statute was. I went over that on one of my videos. You can look up what a statute was. What a statute, all it is a rule from the corporation. And it says that right in the thing. But yet they're saying it's a law. Attorneys, the best way to tell when an attorney is lying is their mouth moving. And I'm not every attorney is that way. I like to believe, but I'm just going to throw it out there because I haven't found one that
I hear you.
So that's how you tell with that. So when you go into court, you need to remember these things. It's not going to be fair. They don't have to give you no constitutional rights. The only thing that you can do is control the court with the jurisdiction issue, or like what we do, file your lawsuit in a higher court, which forces that court to go sit the hell down until the higher court's done. And the higher court's going to be working really hard to get you out of there because they don't really want to get in the middle of this poopy mess. And yeah, so if at the end of the day, it's not going to be about your stuff. It's not going to be about who the servicer was. It's not going to be about none of that. It's not going to be about the loan. It's going to be, at the end of the day, it's going to be about you defending yourself while they're trying to throw you out of court. Because I tell you right now, you go to court with my stuff, okay, they ain't gonna want to have a hearing. Okay.
You're gonna make them so confused. They're gonna like, where is this person coming up with this stuff?
Well, and you know, it's keeping it simple. Yeah. Okay, start out at the gate. The first thing they want to argue about is why you put the attorney on there. Why, I had a lady went to file her stuff and the clerk scratched out the attorney's name and started writing. And she's like, oh, no, you can't do that. And she said, well, I thought you just had it wrong. No. And she knew what she was talking about. She told him, no, look, see, here's the exhibit right here. I added the exhibit. This is the petition that they filed. It's only signed by the attorney. No one from the bank signed it. And the clerk was like, oh, huh. Would you like to be on this too? Because I can add your butt right on there. But I think she made her point. They're not used to people being educated. Most of the time, people don't realize that the clerk is not your friend. Oh, they're really nice. Yes, and we're here to help. And then they go back there and read your stuff. And then they come back and get in your face. Mm-hmm. And they tell you, oh, well, we can't file this because, it doesn't have this right, or it doesn't have, no. At the end of the day, if you ever have to face that problem, what you need to do is you need to look, first off, you need to get out the little pad, one of the police use when they show up the second time at your house and ask you the same questions, and this time they're writing down the answers. Okay, you get your little pad out and you ask for their names or their employee number or whatever, so that, if your legal team needs to add them to your claim, then you'll have the information that you need to make them do that. And so my question is, do you have the authority to make a legal determination on my pleadings?
Very good question. Very good question.
And don't say another word. It's kind of like selling cars. I sell cars for free. It's like selling cars. You know, once you throw the thing on the table, the first person that speaks is the one that's losing. So don't say a word. Just like that.
Yep. Because they get confused.
And when it tells them, you know what you're talking about. Because most people are nervous. And I'll say, they just keep on talking, you know. They're like, okay, this person, you know, once they smell fear. So people don't realize that anytime you go into court, anytime you're talking to an officer of the court, they're sizing you up to make the determination if they can throw you under the bus or what it's going to take, how they're going to be able to deceive you and get you off the path.
Okay.
And people have to understand you don't have no rights in court. No. Now, one of the things that we want to talk about too is your attorney. The attorneys. So, and we've had this happen a few times, and the only way I can know this stuff is if you know. So the attorneys will go in and move to dismiss your lawsuit on behalf of the lender. They'll say, this is the attorney on behalf of the lender, and we're moving to dismiss this because we didn't have anything to do with the foreclosure. And I've had people who had that happen to them. And I'm like, so number one, people have to do your homework. And I tell them, don't call me the same day you get stuff in the mail, okay? Do your homework first. Figure out what it is and what your game plan is. So I told her in that case, the attorney is saying he's working on behalf of the lender. So who's the attorney work for? All you gotta do is Google his name. She's like, oh my God. Like, he works for the same law firm that you're suing, right? Damn, how did you know that? It's like, dude, I was born this morning, but it was early.
Oh, that's so cool. Yeah.
Yeah. And so her next words were, I know how to handle this. I was like, okay, then. I was about ready to blow the whistle on you. No, but you know, so now she just needs to object because, or to file her motion to. We have a document in the package to take care of her notice of claim, or to actually, we have a document in package to remove the notice of appearance from the record for the attorney who is actually working for the law firm. And so, yeah, so she just stuck that right in their face. And the motion to strike the attorney's notice of appearance. There you go. So people need to understand that the attorneys are lying. Okay, the lender has nothing to do with it, and if the lender did have something to do with it, they would not be able to move to dismiss your case. Okay, they would only be able to move to, they would be able to request that they be removed, because there's no grounds to dismiss your case just because they're not a party, directly speaking.
Right.
But here's the deal, and I filled out, I helped a young lady with a little bit of a response to this issue. Here's the deal. Nobody's walking away because the lender is violated gap in the process. And remember the 6 things that we're saying was missing from the contract. The lender is responsible for that because the lender, and the lender never made any loan. What they did was they acted as an exchanger and exchanged your promissory note, which means that the alleged loan was generated with your own signature. So the lender is conspirating with the attorneys from the title company to, and they are involved with real estate defraud because they did not deliver the deed to you as mandated by law. Now, I'm going to share this with you, Gene, too. And
There's a lot of players in this game now. We've got a lot of players in this game.
Yeah. I'm gonna share this with you, Gene, too. And this is going to blow some people's socks off. Now, this is my opinion based off of the signatures and the research.
Right.
The main reason why they want to get your deed registered in the county recorder's office is because it allowed the bank to file the fake mortgage lien against your property. Think about that for a minute. That's the beginning. So I'm like, no, the bank dude is not walking nowhere, because all the stuff they did in the last loan is what we need to be talking about right now anyway. And at the end of the day, I don't care if it's 100 bankers. If I wanted to call them all into court, they're all going to bring their butt into court, and we're going to let the jury decide who get to walk and how much liability each one of them has. That's what we're going to do, because until the facts are put on the court record and they're able to be like defended, if they can do that or whatever, that's the process, then there ain't nobody leaving. So yeah, that's what we addressed. And I kind of, I've been doing this for so long, it's like the response, I like, oh hell no. She's like, I've been working on this. I do, just let me send you over something. Actually, I sent you a copy of what I sent her. It's like, it came out kind of long. But,
oh yeah, I saw it. Yeah.
Yeah, but it's a good read, because it backs them right in the corner. And they're not going to want to talk about any of that stuff. And so we're going to see. And this young lady is from Mexico. She's a Mexican lady. She's going to, at some point, we're going to open up a new website in Spanish. And I'm in the process of building a course that's going to be in Spanish. And she's going to be the instructor for that course, because I speak Spanish a little, but not enough to make sure people understand, because this is like pretty serious when we are, at this point of the program. So she's going to help me as an instructor with that part, so we can actually open up what we're doing to help Mexican people too. Because I grew up in Arizona, and I have, I live with Mexican families my whole life, and and they take a beating, because there's no one they can trust. And if you do trust an attorney, then we already know how that's going to go. So and then when you run out of money, you're kind of stuck. And so I'm really excited about expanding my business to that point. I have a lot of things that I want to do.
That's beautiful, man.
In the process of getting ourselves in position to do those things.
That's beautiful.
Okay, so one of the other things that we want to talk is the lender claiming that federal court does not have jurisdiction. This is good. This is good. So whenever that happens, you should laugh first. Okay, if that happens to you, if they say that in court, I would start laughing. And then I would let them know that the fact of the matter is, federal court is the only court that should be hearing the claim, should have heard their claim that they filed in state court. State court does not have jurisdiction to hear a foreclosure case because it's filed by a foreign agent.
Wow.
Now think about that.
Yep.
That would be like having someone from another state suing you no. That'd be worse. That'd be like somebody from another country suing you in state court. Oh, hell no. Yeah. And if you don't understand FARA, Foreign Agent Registration Act, look it up. And when you look it up, go straight to the government page. Okay, there's a whole bunch of stuff, but remember, like I said, sometimes attorneys write stuff or whatever. Go to the government. There's actually a national attorney general that's supposed to be in charge of policing FARA. FARA is the Foreign Agent Registration Act. These attorneys are considered foreign agents, and they're supposed to register. And not only are they supposed to be registered with the federal government, they are supposed to like provide their who they work for, their earnings, all of. I mean, do your research. I was like, holy cow. Yeah, and so people say, oh, but you bring that up in court, they just ignore you. Well, of course they're going to ignore you in court if they can, because the judge is also a bar member, and I know damn well ain't none of them registered. So, but you know, you use it outside of court and in court. But the problem is people don't know how to use it. So most people think, oh, I'm gonna let the judge rule. Judge, you're gonna rule because the judge ain't gonna. Are you kidding me? So what you want to do is you want to make him dismiss your stuff or object to whatever, and then you want to do the appeal process and then attack the judge for. I have a motion in the packet to recuse the judge, and people don't realize you don't have to prove anything. All you have to do to recuse the judge is show the appearance of impartiality. That's it. And that's really easy to show when they're letting their attorneys go through and they ain't following freaking rules or the law. So, you know, you put yourself in a position, and then when they stomp you in the face, you go after them. Why do we have to be the whole with the judge? And no, the judge is not doing what the judge is supposed to be doing. So you can either go sit down. I mean, at the end of the day, it don't matter who you sue, as long as somebody's been held responsible for what they've been doing to you.
Yeah, and you said that you could
I'll tell
also.
you right now, when you bring that up and you throw the judge on the table, most of the time they're like, oh, come on through. Now, they're still going to be trying to stab you in the back, but at least you'll get past the first hurdle.
You know, it's funny. You mentioned it in earlier videos we did. You said that they don't name a lot of people in the lawsuit, and I want to reiterate that because that's very important to just keep it very simple, maybe with one or two people or maybe one person, so you can direct that right to that one person.
Yeah, and the reason that is because in their conventional process, they add all of those people, and then it gets very confusing. And then all of those people will force you to respond to them. And if you miss one response, they're going to move to dismiss it. Or they're going to do like the attorney did in the case that we just talked about, and move to dismiss it because they're not, they don't have nothing to do with the foreclosure, or they're in another state. I have them try to move to dismiss one because they're not in the state that their house is in. I'm like, are you kidding me? It's really funny because this Mexican lady, she went to go file her, I call her girl, but she's like, well, okay, we won't get to the age thing. We'll just write that. She went to file her stuff, and I told her, they're going to give you a hard time. They're going to try and convince you that whatever. And so when she got done, she called me back and she was laughing. And I said, oh, I can't wait to hear this. She's like, yeah, they told me, well, my husband is not a citizen of the United States, so they don't think they're going to be able to file her, her lawsuit. Oh, no, she said her husband's not a citizen of the United States, so the clerk didn't think the judge was going to allow her to go through, her lawsuit to be filed and go through.
Okay.
And so then the clerk said, so do you want me to still file it? And my team member said, oh, yes, please.
It's nice to see other people stick up for other people, especially on your team. I know that's a great thing. So should we take calls in a little bit? You want to take calls?
Oh yeah. Let me turn my fan on.
Yeah, good. I'll give the number out while Coach Neighbors is turning his fan on. The phone number, guys, is 609-585-0400. And I posted the Zoom link in there if anybody wants to come in. If you're an attorney, you want to talk to Guy about any of this, you can do that. You can also call us at 609-585-0400. Tell us what you've been doing. If you're working with Guy on some of his things and you want to share with us where your case is and what's going on with you, you can do that. Any testimonials, any people that want to call, just ask questions to Mr. Coach Neighbors. So we'll see what happens. But you touched on a couple points there. I like the idea that the courts don't like pro se. because you're not on their same same type of level with the lawyers.
Actually, Gene, and that's one of the things I wanted to talk about.
I'm hitting all the points.
The clerk convincing you to use their forms. Okay, they don't like you to file your own stuff. They like you to use their forms. And the reason that is because, well, think about it. I think my lawsuit pages, I don't know, 20 something pages long. Well, their form's only 3 pages. So that kind of is a wrap on that. There's nothing in their form that you're going to be able to address that's going to help you. Okay, their forms are structured to move you through court quickly. That's why it's only 3 pages. And anytime you're being hurried through court, you're getting the shaft because they're not addressing nothing. I mean, I don't even need to go to that. I tell people, do not fill out their forms. And what they'll tell you is, well, just fill out the form and then we'll attach yours to the back as an exhibit. No. What I tell people to do is take the form and fill it out, and then put it in your notebook and give them the document that you need them to file for you. Now, the document I'm talking about doing that with is their lawsuit document. They have a document or they have a form that they consider they want you to fill out for the lawsuit. Mm-hmm. Now you have to fill out the one form to be able to get in court, and but the lawsuit is to what I'm talking about. They have a form that they like you to fill out as the lawsuit. So you're not addressing all of these things. Mm-hmm. And then they can keep it on the administrative side of things and not have to do judicial, because it's actually illegal for them to make a judicial determination as an administrative court. But we don't know about all that.
I don't know. We'll see if we get any calls. There's a lot of people that I guess they're afraid to, they're also afraid to get involved with anything. Fear is one of the, like I said, one of the biggest motivators against people that, and the courts know how to use the fear against them. I wish people would override their fear and just look into what they could accomplish by fighting back. I don't know if you can hear me. Can you still? Oh, we got a phone call.
Somebody's calling.
We got somebody to call. Here we go. Hello, who's on the phone with Coach Neighbors?
Yeah, hi, good morning.
Yes. Yeah, we can hear you. Go ahead.
Should I turn the sound off?
Yeah, turn the sound off on the thing and then just talk. Can you hear him, Coach Neighbors?
Yes.
Go ahead.
Okay. Yeah, Coach, how you doing?
I'm doing pretty good, buddy.
You're breaking up.
Yeah, hang on a minute.
Okay. That's advice to anybody. You call in, please make sure that your other source that you're listening to us on is lowered or muted.
It's muted. It's just bad coverage here. Is this a little better?
Yeah, that's better. Go ahead.
Okay, yeah, I got a couple questions. One, I did research the FAR, and I don't know, I really didn't find anything about, it seemed to be like about foreign country type of registrations, anything about the government page or how they would apply to attorneys. So I was wondering if you could direct me about that. So I'm a little unclear about the FAR thing.
Did you hear that, Coach Neighbors?
Part of it.
Can you repeat that, please?
The FAR means Foreign Agent Registration Act.
Yeah, in my research, I saw like people from other countries need to register or something. I'm thinking the bar attorneys are, because they're, aristocratic, British aristocratic, whatever, that would make them a foreign agent thing? Is that how that works? Or?
Correct.
Right. Where in that can you find the government page with employee where they would people that were living in America, United States, would be considered foreign agents, these attorneys. Where is that in their information? Because I couldn't find it.
So your question is, where is the information that shows?
They're foreign agents?
Yeah, it applies to attorneys, applies to within the United States. Being from all I could find was it seemed to be like people from other countries needs to register. That's from my research.
Well, an attorney is considered a foreign agent because they accept a position of nobility and they're considered to be from England.
Right. Yeah, I got that part. I just didn't see it in their page.
Well, they're not going to show you.
Well, you're right. They're not going to spell it all the way out plain and clear. You have to look in other pages and figure that out because they're trying to put just enough that see, the Foreign Agent Registration Act is actually enacted into federal law. That's why it's so powerful. And I looked it up because I already know that not everything is considered a law just because they say it's a law. It actually was enacted. So they have to have in there at least enough to show that they're trying to do what they're supposed to be doing.
Okay. The other thing I wanted to ask was regarding you mentioned the Enactment Clause. I'm glad you brought that up. And in my research in the state stuff here, it just states that when they make a bill, which they make zillions of them, and I guess they first write it up to get it approved and discussed and all that stuff. They put it on the top of the page, and then it gets voted on. They vote it in, and they sign it. The governor signs it or whatever, and then it's miraculously law, so-called law anyway. We all know they're corporations, but they're saying it's law. So I'm a little unclear. Is it law, or they enforce it as law once they, I guess, put it in the statutes or whatever, or it's signed by the governor, or if he vetoes it, I guess they just put it in anyway. So if they want to.
Well, so if I understand your question,
on that part where it says it's enacted by that enacting clause, which is pretty standard, I guess, everywhere, but whatever their state is. But I don't see it in the statutes. I only see that states that they put it on the bill, I guess, when it's first introduced. So if you could talk on that a little bit, I'm going to clarify that for me. I'd appreciate it.
Well, what you said in the beginning is true. If they have a bill, if they do the things and go through the thing and they vote, then that's a bill. But the problem is the revised codes and statutes don't go through that, or I don't know what they go through. What I know is that revised codes and statutes do not have the three elements necessary to be considered a law. And those elements, if you do research on the enacting clause, those elements need to be with the law. They can't be in another book and all this stuff. They need to be with the law, and they are not. And this is something that people should be, most of the people in my groups, they have to go figure it out. I don't tell them what the elements are. I tell them about the elements and how to get them on the path, and they have to go figure it out. But since you guys are here on Hamilton Radio, and I'm like really grateful that Gene is allowing me to talk with people, I'm just throwing it on the table because that would be grounds right there to dismiss your case. Just one thing, to dismiss your foreclosure case and get them out of your face. And they're not going to want people to know about that. And that's really the goal anyway, is to come at them with what they don't want to talk about.
Well,
So,
I haven't filed that jurisdictional challenge yet. I'm just kind of wondering what have been the reactions from your other students who have filed it from the judges. What's been their experiences with that?
Well, the jurisdictional challenge, right now I only have a couple of students enrolled, and my ad has been terrible on AdWords, and I'm still learning how to take care of that. So I got a couple of students enrolled, but the jurisdictional challenge the jurisdictional challenge with an affidavit. I had to say the whole thing because in all of the packages of jurisdictional challenges and the lawsuit packages, now the online course, the documents for the online course are different. and they have the jurisdictional challenge in them as the lead document you'll be filing in your case in state court to blow that up before you file your case in federal court. Now, the jurisdictional challenge with an affidavit, now just think about it. What they're doing is fraud, and they can't answer by counter affidavit.
Right.
So 6 people have used it. The 7th person ended up, well, the 7th person missed a couple of steps in removing the case from eviction court over to federal court, and he allowed the state judge to rule. And so the state judge just took over and dismissed all of his stuff. That's one person, because that person already didn't attack the judge when the judge first started stepping on them. The other 6 people, their cases have been stalled off. In my foreclosure rescue page, I allowed people in that group to purchase the document for like $200, okay? I mean, what a steal. Stop your foreclosure for $200. Because I wanted to see how it worked and if I need to add anything to it, because that's going to be the lead document for the online course. Now, the strategy for that document I took out of the PDF that the banker's secret manual, which is the same PDF the radio station has available for you guys for, like, I don't know, for a donation of like $10 or something.
That's what we have it for. Yep.
And the strategies in the online course came from that PDF, and it is so, oh my God, it is. I haven't had time to read the whole thing. I just thumbed through it and looked at the one chapter that like jumped out at me, and that was the banker's secret fear. And out of that chapter, oh my God, I was like, I was like, yes. And I woke my wife up. She's like, what the hell? That's what we're addressing. And one of the things that we're doing.
It had a lot of good stuff in it. It's a long manual. One thing that was in there was struck me kind of interesting. I was wondering what you thought about it. Was they mentioned one of their fears was if you paid the note with another note. I know there's that guy in Texas who was talking about that before a few years back. But I was a little leery of it because I thought they might try to charge you with, using a false instrument or some.
Well, and you're right. They do talk about that, and that is one of the strategies that they say you can say. They're not, you can do that. What they're saying too is that the fear that you're going to say that was part of what you agreed to in the original contract. See, back in the day, everyone wanted to where's your note, show me the note, and all that stuff. Okay, this is a different approach to it, and it's really cool because what you're saying is basically, in a nutshell, what you're saying is the 6 things that's missing from the contract that they filed in court are in the original contract. Those 6 things that are missing are the things. How can I? Are the things that should have happened had that whole mortgage deal went the way that it was supposed to have went. Okay, that's the way that is, and it didn't go that way. So either way they answer, they're screwed. They can't say we did follow gap because they didn't. If they meant they didn't follow gap, then they're in trouble because they violated federal laws. So it backs them in the corner. The thing that a lot of time people have a hard time was taking that information and sticking it in their face, because people are so worried about, well, how do I prove it? How do I, whatever. They started this. It's up to them to do the proving. All you got to do is throw it on the table and get it in court, and then let them decide if they want to prove it or if they want to.
I think that people are more afraid of the judge than they are the attorneys, the judges, because you're not going to be on his nice side when you go after the attorneys, right? Something like they're not prepared for.
So state it again. I didn't hear the beginning of your statement.
Caller, we're trying to hear. What'd you say?
Hear me okay?
Yeah, we couldn't. We lost what you said at the beginning there.
Yeah, it's bad weather. I was just saying people are probably more afraid of, when you start using unconventional stuff, the judge is going to not like you because you're not playing by their rules.
Well, the judge is not, yeah, the judge is not gonna like you anyway, unless you just go in there and let them take your stuff.
Right.
Because they're all on the same team.
They do give you favorable decisions for a while, as long as you're feeding money into their bar member pockets.
That's it. Hey, caller, where are you calling from and what's your name? First name.
My name's Paul. I'm in Hawaii here, calling from Hawaii.
Hawaii. Okay, that's
Oh, hey, Paul, how you doing, man?
Yeah. Well, I got a filing date tomorrow in state court, where they filed an amended complaint on me. They made a substitute plaintiff, which seems to be I was reading up on it last night. I was up all night. The fraud seems to be what they do now when they can't get you out early on. I've been in this thing for 11 years. And they kept coming at me. I'm really fed up with it.
Oh,
so anyway, I have a new complaint, even though it's well beyond the statute of 6 years for a contract. So what they're doing now is they're using a foreclosure statute, which must be a new one. They have 20 years now to come at you.
So Paul.
Well, not a contract law thing.
Paul.
Yeah.
So we just talked about the fact that the statutes don't have the necessary elements to be considered a valid law. Let me ask you something. So do you have the jurisdictional challenge?
Oh, I have the other one. I have the state citizen one, but I haven't got my passport ready on that one.
No. Do you have the jurisdictional challenge with an affidavit?
No.
The document that we were talking about.
Yeah, no, not yet. I'm on the fence. I should get it and then file it tomorrow. That's what one of the things on my mind, foremost on my mind right now, actually.
Dude, if you get that and you file it tomorrow, well, so if you want to do that, you'll have to email it to me, because it's not posted on my website for everybody to get because of the online course. And I decided when my online course is full, when I have
it on my email, I can just click it and grab it.
Okay, you have the link already?
Everybody says do a motion to dismiss. Don't do an answer, because then that escalates their time to try to come after you with their summary motion BS. If you do the motion to dismiss, do you only get one shot at this? I was reading one guy on that park. He was a reference on your website as well that got some great stuff that, I don't know, from the park from, I think, Florida. Said something about they had some motions, and he filed 6 motions to dismiss one time, stalled his proceedings for 18 months to a couple of years. I thought you could only file one motion. You get one shot at it. Can you clarify that for me?
Well, I don't do things the way that other people do, and that's way too much stuff. So I'll tell you right now, if you file the jurisdictional challenge with an affidavit, you won't have to be worrying about the rest of that stuff.
Right.
So the jurisdictional challenge with an affidavit, Paul, also comes with a motion to moot all of the filings that they filed in the case until they prove jurisdiction on the record. And in that document, you are demanding that the judge forced attorneys to prove the jurisdiction on the record. So, and they can't. So basically what you're doing is you're going in, challenging jurisdiction, and the motion to moot came to me one night at the end of the day when I was laying there wondering if I emailed everybody and said, and done everything that I told everybody I was going to do. And I was like, man, that is a great idea. Yeah. And I have a judicial foreclosure case I'm helping a person with, and she filed basically I made these documents for her. She's a military vet and a very good friend of mine. So she doesn't handle stress real well. So I put together this program to help her stop her stuff without having to go to court. And her stuff started last October, I want to say. Yeah, and it's judicial. And yeah, she has not been to a single court hearing, and there hasn't been nobody at her house taking pictures or none of that stuff. And they cannot answer to the jurisdictional challenge with an affidavit. So if they respond, they fail to respond by a counter affidavit, then it's not a proper response. So that's what they did. And they didn't even address the issue of the jurisdiction and none of that stuff. And then they asked for additional time to respond to the motion to moot all their stuff. And I kind of thought maybe they would wait. They were thinking that we would wait until the time passed. So they say we're out of time to answer. I don't know. I'm not sure what their goal was, but we didn't have to wait, because if they can't respond by counter affidavit, then their stuff is moot anyway. So, and so right now,
30 days.
they were not able to respond on the 19th of last month to the motion to moot until they approved jurisdiction on the record. They could not respond to it. So we followed up with our brand new motion to for summary judgment. And we did not serve the attorneys a copy of the motion for summary judgment because they're in default. And so when they said, well, why don't we file they're in default? I don't have to file that crap. They already know they're in default. So we're just going to skip that and move right into, and we're not serving them, and we're just asking the judge to rule on the record from the record and make a ruling without them arguing, because they don't deserve a right to argue if they're in default.
Coach Neighbors, he wanted to know how many days he has to respond. Depends on the state, right? Or
right, that depends on the state. So I don't know that. I tell people you got to figure that out in your state, because some states 21 days is what I always was trained to do, but people in New York they say they have like 30 days. So, and then with COVID-19, I mean, I don't know, but I would not respond. If it was me, I would file that either the challenge, the affidavit of jurisdictional challenge with an affidavit, I would file that, and the motion to moot all their stuff. That would be my response, but I wouldn't file it as a response, because basically what you're going to do is blow their case up in their face. And then the game plan would be to file your wrongful foreclosure / breach of contract in federal court. And then when they can't respond to that, you can use that as an exhibit in your lawsuit in federal court.
Yeah, that's what
And I know, think about it now. See, people tell me, oh, you think outside the box. No, there's no box. There's no box. So you show that they could not respond to your challenge in state court. They can't respond and show that state court had jurisdiction to do anything to you in the first place. So federal court needs to just have a hearing to see how much they want to pay you.
right.
Yeah, that sounds like a really good idea. But the COVID thing, I know they're quarantining. You can't go off island. I have to go to the other island to file federal court. So that they're making it really difficult right now. That's why I was kind of waiting. The other thing, I was kind of concerned that they might default me because I have to answer this new amended complaint, bogus complaint. If I don't file an answer or a motion to dismiss, it's kind of what they'll ignore the jurisdictional challenge and just say, well, you're in default, you didn't answer the complaint. So what's your thoughts on that?
Paul, I don't really do speculating, okay? You have to file your stuff and get your lawsuit filed in federal court, and you take over them. I mean, when you challenge them with this jurisdictional challenge with an affidavit, and your motion to moot all of the stuff that they filed until they approve. If the judge don't do that, then you need to be going after the judge. Don't waste your time, because you can do all of that stuff, and if you don't make the judge respect you, you're gonna have crap for the program.
See, I think what's going on here, Coach Neighbors and Paul, is, and I went through it for 10 years, is they try to get you caught up in the game of going back and forth. He's telling you to just go after the judge and complete about the jurisdiction and go with that, because you get caught up in that game back and forth, you're going to slip up. And I think that's what they want you to do.
Well, there's no slipping up. If you get caught up in their game, you're done, because they already said. People forget that the attorneys are the ones that structured that whole program that you are in right now.
Well, he's already caught up in the game, he said. So how to get out of it?
So take control of it.
Take control of the game now.
You got to get control of it. Yeah, exactly. So I don't want them to get a default and then try to use that to,
Paul, It don't matter what they get, okay? You have 15 years to challenge jurisdiction. Now, I say that because you seem to be like, have fear about that. You can't worry about what they're doing. One of my coaches used to tell me, well, we're not going to go over all of their stuff because if we're doing our job, we already know what they're going to be doing. They're going to be getting their butt kicked.
Get a default, you know what I mean? Like, this is what they've been trying to do. They didn't even send me the complaint. They filed this thing during the COVID, which is illegal. And now they're hoping I don't respond. So if I don't respond, I don't want to give them anything.
Well, you do whatever you want to do, man, because I'm not going to argue with you on that. But I will tell you, Smell Maxwell, she's in the group. Her dad, they defaulted him, and they were selling his house. And she filed her document, the jurisdictional challenge with an affidavit. And not only did it stop the sale of her dad's house, it overturned the default judgment, and she was already in the process of filing her lawsuit in the federal court. So once she got that case opened back up, she just moved it over to be connected to the title dispute, because the title dispute's in a higher court. So the lower court don't have jurisdiction to do crap if the title dispute's in a higher court. And I have documents in the online course. I have everything that I put together to help people with in this foreclosure situation is included in that course. I also last week added an extra lecture and chapter and an extra lawsuit package. And that lawsuit package that I added was the lawsuit package for legal malpractice. So people who had an attorney rip them off, you can go after them. Now, remember, or not remember, you have to understand that the attorney structured this system that we're dealing with. So like fraud, legal malpractice, oh my God. For legal malpractice, the bar is so high to prove damages, you almost have to have a lot of people die. So what I've done is I set up this lawsuit for legal malpractice / breach of contract. And you're demanding your attorney fees be returned to you. And I've put the documents in there for that. And if you think about it, if you pay an attorney, it's not real hard to prove they threw you under the bus at the end of the day. And now you can go after them for that. Who knows? Maybe you get your attorney fee back or pay for the course that or something. I don't know. But I threw that in there just because I wanted to add additional value to the program. And I'm also going to make another adjustment and add a section on how I actually structure the documents, because I want people who invest in the course to be able to learn how to do everything that I'm doing. And there will only be limited by their goal or the amount of time that they spend studying. Some people might want to use the course to start their own paralegal service. Some people might want to use the course to protect their real investments. Some people might want to use the course to help protect elderly people in their church. I have a lady that's doing that right now. So I'm trying to make sure the course is set up to cover everything. And that's where we're going. But you, my friend, need to invest. That will be the best $200 that you can invest in your situation. And when I get 5 people in the group, I'm going to close that down. So, and I mentioned that in most of the posts in the Facebook page. So if you're interested in that, I'm not trying to push to sell, but I'm just trying to keep it real with you. Once I get 5 people in the group, that'll be my first full group.
I'd have to use it tomorrow. I just, the thing is, I really didn't want to be on my heels and deal with eviction. I want to get them to go away for a little while and then go do the federal lawsuit, especially with the travel problems getting to the court over there right now.
Well, Paul, it's no go away with me. Okay, wait. There's no go away for a little while.
Contracts. Hello,
Paul. He's talking to you while you're talking. He's just said he doesn't see it going away for a while. It didn't go away for 11 years.
No,
right?
I meant this deadline filing so they can default me. I just I was considering doing a motion to dismiss, which is kind of playing in their system, I know, but they haven't included anything. There's no contract. There's no.
So why would you do that?
There's no nothing. They just basically filed a complaint and a third party with no proof, no nothing. But,
So that's what they always do, Paul, because they know that you're going to play into that.
you know, just dismiss it.
They're not going to do that, Paul, because you're not in a fair court. You're
Well,
not
you
in
can't be
that court.
afraid of this either. You can't have fear. You've been doing this for 11 years. So don't have the
Well, I
fear.
haven't given them any defaults in 11 years. That's why I'm still here, you know? I don't want
A
to.
default doesn't mean anything.
Doesn't
If
mean
you
anything.
got what you need to get in their face, man.
Yeah, he's telling you it doesn't mean anything. Are you listening to him, Paul? I'm sorry?
I didn't hear him, Bob.
He's telling you it doesn't mean anything. A default doesn't mean anything. You could still go to get them against jurisdiction. And with your the other thing.
Paul, what I'm going to suggest is that you should get.
I want to give him that if I can help it, you know?
Well, listen to what he's saying. Go ahead, Coach Neighbors, talk again.
Paul, you need to invest in that document and read it. And when you get done reading it, you call me. Well, send me a text message first and let me know that you're calling me, and I will let you know if I'm in a meeting or something, and we can talk. But you're not going to do anything, filing anything in there to dismiss it, because they're not going to dismiss it. You need to take control of it, and I have what you need to do that if you're willing to go and get it and study it and get it filed. And basically what you're going to be doing is challenging and you're going to force them to respond by counter affidavit, which they can't. And you're also going to moot all of the motions that they filed in court. So they're not going to be able to do anything to you unless the judge ignores your jurisdictional challenge with an affidavit. And if that happens, then I have just what you need for that. And that's going to stop them from doing anything to you, because you see what I'm saying? So you need to not worry about all that fear. Just go to that website and get that document. And then when you get done reading that document, you let me know how your fear level is. Okay?
Well, I'll read it today. I'll let you know. I have to file tomorrow. I guess I don't have to. I could go into default, but I really don't want to do that.
Paul, you have to.
Well, I don't want to talk about the default no more, Paul. Okay? You get done reading the document, and then if you still think you need to worry about.
Not a full read in my book either. The other question I had before I go is I wanted to ask you about this issue getting back to the security instruments. Came across this guy who's, I guess he's attorney trained, but he found out he wanted to be a bar attorney because they're crooks. So he's kind of supposedly working for the good guys. And his approach, he says he's done this a few times, is to send the attorneys a letter about telling them that he didn't surrender his security interest in the note, and he has the superior position, kind of claiming his position, because basically, you created the instrument, and through fraud, not telling you, they just basically, ignored your interest. So that's what he's doing. He's which is kind of set him up for not paying taxes on the, I guess they didn't file things they're supposed to, and they're in securities fraud and tax fraud. So he kind of like alludes to that in the letter he sends them. And I guess it has to do with the birth certificate, signing it and all that, says to his trust. So I was wondering what your thoughts were on that, if you were up on that, if you were.
No, I don't know. I don't know anything about that.
What you thought about that?
I don't know anything about that. But what I do know is there's no trust, because it never makes it to the trust. It's securitized before it gets to the trust. That's part of the problem. And once it's securitized and it's not in the trust, then it's void, and they can't collect on it because they can't prove who owns it or where it is or any of that. So no, I don't do all that stuff. I had a lady talking about being a secured party creditor and all that. And comparing that to the passport process.
1933 bankruptcy, something about real, when they monetized this all. And,
yeah, no, I don't do nothing with that. I have my program set up, and I stick to just what I do in my program, because I research all that and I know what I'm talking about on that, and it's helping people. So, but thanks for calling in, buddy. You let me know when you get the document if you have any questions after you read it, okay?
Hey, Paul, give us a call back next week. Let us know what's going on, okay?
Sounds good. Thanks again for your time.
Okay, bye-bye. All right, I think there's another caller coming in. I want to see. Hello, who's on the line? Hello? Okay, somebody else was calling in, so here we go. Hello, who's on the line? This is for Coach Neighbors.
Yes, I'm a student of his. My name is Kim Valenti.
Hi, Kim.
And I just wanted to make sure that this was a working number because I just received it.
Yeah, it's a working number, and Coach Neighbors is on the line.
Hi, Kim.
Hi, are we live?
Yes, you are.
Hi, Coach. How you doing?
I'm doing pretty good. So you're live now. We can't let you go without saying something.
Thank you for calling.
You're welcome.
You have any questions?
I just wanted to get the time straightened out of when I could call, and this is daily, Monday through Friday?
No, only Wednesdays.
Oh, only Wednesdays. Okay.
Yeah. I wish I could do it daily. I just can't.
Yeah, me either, because I have to help some people. So Kim, have you had a chance to look at the curriculum in the online course? I mean, I know you got the non-judicial, you need the judicial, we're working that out, but the curriculum and stuff is almost the same in every. Did you get a chance to review the jurisdictional challenge with an affidavit?
No, I haven't, not yet. And I don't have my questions ready just yet. But I just wanted to know if there was a video for each and every package.
Well, you have the online course, Kim. Just go to it and look. There's a video there's lectures and videos. So I don't know if there's one for every package, but when you go to the online course, you'll see it'll have a little YouTube symbol for the curriculum lectures that have videos in them.
Okay.
So,
and for because I am enrolled in the course and I paid for the course, the new packages, the new files, they have more to them. There's more information.
Well, the online course has different documents in them that are more powerful. Yes, that's
okay.
Yeah.
So there is a difference between. Okay.
Well, absolutely. And I can't wait till people. So the biggest difference is there's a couple of differences, but one of the biggest differences, the jurisdictional challenge with an affidavit is designed to pretty much end the case in state court. It blows their case up. And then you're able to use the fact that they can't respond by counter affidavit or to any on the merits. You use that as evidence in your lawsuit that you file in federal court. So you really don't need it, but it's nice to have because it shows that in the lower court, they weren't able to respond, and that the lower court shouldn't have been filed in the lower court in the first place. So.
Right, and because we're at a new they can't compete against the 6 missing statues, which is not a valid law. So they're playing by their own rules, and we're
no, yeah, well, not when you file your own case. And then they'll be playing by your rules.
Right. So basically, without 2 signatures, it's not a valid contract.
No, it's not the signatures that are the problem, Kim. Without 2 signatures, it's a unilateral contract. Means that you're the only one that signed it. So you can call the terms however you want to. But we're not going to get into that because we're not going to let them get into that. We're going to keep them at the gate with the jurisdiction. So you should let me know when you review that document, Kim, and let me know what you think about it. I'd like you to leave in the group or something or maybe update your, it would be cool if you could review everything in the course that you have and just check everything out and leave me a review basically stating that it has value and you're pleased with it, and that you'll do a follow-up later on to let everybody know how it goes. Because it's hard for me to wait until the end of everybody's stuff to get a review, because I'm not saying that I'm going to help you win. I'm saying I'm going to help you get to stay in your house. So if I'm helping you get to stay in your house, and I want people to see that what you're getting is real and has value. And that's what I'm asking people to leave the review about. And then to follow up later on how well it worked.
Okay.
Okay.
As soon as I find out anything, I will definitely give my testimony and let you know where the court stands and where I stand with the court.
Well, I don't need to know where the court stands, hon, because I already know. I already know where they stand. So you check it out. Let me know what you think about it, Kim. Thanks for calling in.
Thank you, Kim.
Oh, you're welcome.
Bye-bye.
Bye-bye.
Okay, Coach. God, we've went a half an hour over. That's good, though. We're getting calls now. That's good.
Yeah, getting some calls.
That's good. Anyone from Hawaii? I want to thank Paul for calling in. So any other comments or information where we can talk about, like, for next week, or what you're going to be doing next week? Give it a heads up.
Yeah, well, I haven't really thought about it yet. I'll just leave a link about what we're going to talk about. Because, a lot of times I think about it or whatever, and I'll say something, and then someone will call me or send me a message with something that's going on. Like in this case, I was like, well, you know what? I need to let people know what they're going to be facing when they get to court,
Yeah,
and
absolutely. I
I have a lady, she told me, well, the judge dismissed it without prejudice, so your paperwork didn't work. I started laughing. Okay, I'm sorry, I don't mean to laugh, but okay, look, dude, then if they dismissed it without prejudice, that means that there's some kind of a problem, he's saying, and you just need to correct it and refile it. So they're gonna pay no money. No, dude, you haven't done your homework. I'm glad to send you to the bench. Okay, she got kind of a little grumpy with me because, well, I just don't do the anxiety too well, just stay focused. But
yeah, and I sensed that in Paul too. I think he was really stressed, because I know after 10 years of when I was dealing with the banks and going back and forth lenders and stuff like that, it was so stressing me out that, upon being a notary and trying to be a paralegal and other things, I got to the point where, like, enough is enough. I just want to move on in my life, and that I was able to do that. Some people aren't. So this is where you step in and you try to correct that and fix that for them. But a lot of them got to have, like you said, they got to take the ball. They got to have balls. They got to get involved. They got to
they got to have the guts to step up to the plate and take charge. Because, and I tell people, if you have fear or if you don't want to take charge, getting in my program is not the best thing, because my stuff is kind of in their face. And if you're going down that road, you need to be ready to roll. I have a picture of a guy walking down the little strip to go into the boxing ring, the big giant boxing ring. Well, I put it on, I post it all the time. Yep, we finna go get some stuff done. And I love pictures of bombers. So whenever someone's about ready to go file their document, I'm going to send this bomber, this special delivery vehicle out to go help so-and-so deliver their package to the court. I don't want to say bomb, because then they might be flagging me or something, But yeah, so I'll send a picture of that big giant bomber. Yeah, it's pretty cool. People are like, oh my God, and that's pretty much what it is when they show up with it. So.
No, that's great. All right, boss. Well, we can wrap it up.
So you guys can reach me at my email address if you have any questions at winincourts1@gmail.com. That's WININCOURTS and the number 1@gmail.com. Or you can go to my website at winincourtnow.com and check out our lawsuit packages. when you go to the website, right underneath the big words at the top to the left side is a link to the online course. So you can click on that and go to the online course if you're interested in that, and check that out. Also, you guys, please subscribe to my YouTube channel and help me reach that 1,000 subscriber goal and those 4,000 hours of watch time, so I can reduce the prices of my products again once I'm able to monetize my YouTube channel. So go to the channel, click the bell and click the thing and do the stuff so that you can get everything when class starts, because you need to make sure you're ready.
And don't forget, we got the PDF for them. So if they want to contact me, admin@hamiltonradio.net, I'll send you the PDF for a donation of $10. And like he said, that's a great deal. So I don't have a problem with that.
It's a great deal, and that donation helps a lot of people, helps the radio station too, help me be able to help you. That's how that helped all the way. You know, they always say that it rolls downhill, you know, so this is good stuff rolling downhill.
That's good stuff. Yeah. All right. We'll see you next week, Coach Neighbors. Thanks for a wonderful show.
Okay, buddy. Good. Have a good day.
All right. Bye-bye.